Still with us here at Court TV, criminal defense attorney Melaney LaGrone. Melaney, thank you for being here with us still this afternoon. Here's the thing. So what I just took away from that testimony and the cross-examination was at grand jury, this witness testified based on the cell phone data that he had at the time and his understanding at the time, the defendant could not have been home. What he now knows is, the only thing he knows is where the phone was. It doesn't mean that is where the defendant was or wasn't, but rather this is where the phone was. How much does that impact this case? We can't go back to grand jury. We can't move backwards in time. So here we are at trial. Is this significant from your perspective?
I believe it is. I mean, we have to look at reasonable doubt, and that could put a doubt in the jury's mind as to where the defendant was located at the time of the murders. So the fact that he was not there, or his phone was not there, and everyone usually has their phones on them 24/7, could be enough for the jury to say, well, he wasn't there, and there's reasonable doubt.
So the defense attorney got back up on recross and went after him again about it to basically then get in an argument a little bit and say, why can't you just admit you were wrong? The witness says, well, I have said I'm wrong throughout this. And the judge said, move on or sit down. And the defense attorney continued. And the judge said again, move on or sit down. How hard is it to walk the line? I know what I think as a judge, but what do you think as a defense attorney to walk the line and not frustrate or anger or aggravate the judge who's hearing the case?
Well, that's our job. We have to vigorously advocate for our clients. And at the end of the day, if someone made a mistake that's as big as this, you definitely want to get it across. But you want to just get it kind of right there to the edge before you irritate the judge and even irritate the jury. And I think he got to about that line.
And I think that's the best point, what you just made about as a judge, when I hear these cases, it's one thing if they cross a line and I have to reprimand. It's another thing if you aggravate the jury with the questions. In the last 30 seconds or so, what, if anything, do you make of the defendant's body language, facial expressions that changed throughout his watching the trial?
He seemed to get just kind of very irritated, which I could understand. He was shaking his head a lot, basically disagreeing with, the testimony. And he was just kind of, I don't think he had like a nonchalant nature about himself, but I think he just has almost like a disbelief type of nature.
And we have a little bit more time, as a defense attorney, what do you tell your client, if anything, about how you want them to act or not act when they are in trial and you are trying the case?
That's a great question, Judge Ashley. And usually I tell them just don't do anything. Sit here with just a blank stare, if at all possible. Don't make eye contact with anyone. If you have anything that you need to say to me, write it on a piece of paper or something that you don't agree with. But a lot of times, the shaking of the head or the getting upset and things like that has an impact on the jury because they watch everything that the defendant does.
Right. And I remember when I was trying cases as a trial attorney and I couldn't see the parties simply because I was focused on what I was doing with the witness, I made sure someone else from my office was there that could take note of those things because it can give you some significant feedback. After the break, we are going to break down the testimony today in the trial of Christian Martin with Court TV legal correspondent Julia Janae. We'll be right back on the other side.